Hi, I'm Mara Tespot of Bott & Associates. Thanks for watching our blog today. Our topic is the death probate process in the state of Illinois. So this is basically how it works, mostly in most counties here in the Chicagoland area, but I will put a caveat that some counties are slightly different. This is primarily Cook County, which is where we do a lot of the probates. So death probate, basically there's three major steps. Our first step is really opening up the probate, and the steps involved in that is making sure we file the petition, and then we file a will. If there is a will, certainly we'll file the will. We'll have a court date where I will go on your behalf, and you don't have to go, you don't have to show up there at all, and I will present to the judge the petition, and then eventually we'll get letters of office issued. The letters of office is kind of like your magic document that allows you to get access to the bank accounts, get access to life insurance, whatever is owned by the decedent. You can use your letters of office to get access to that. Another part of opening the estate is certainly publication. We're going to have to open or file a publication with some type of newspaper to say this estate is opened. Any creditors who want to come out on behalf of, their company against the decedent, they can file a claim. And then the last thing that I always share is that if there is no will, we're typically going to file or get a bond for you, because we have to ensure that the process goes well, and that's giving the court insurance that we'll go through the process properly and appropriately. The second part of probate is administering the estate. So once we got that letters of office, we're going to go ahead and prepare an inventory and figure out what's in there. So now it's going through all the papers that the decedent had and figure out what they owned. We're eventually going to sell and liquidate those assets. So a lot of times that house is a big deal. We're going to start cleaning out that house and eventually sell it. We're also going to pay some bills. So whatever outstanding bills that are coming in the door, we're going to make sure that's paid. And then certainly we can also send out an initial distribution to the beneficiaries if the administrator wants to do that. So after about 6 to 8 months minimum, we can go to step 3, which is closing the estate. So closing the estate just entails getting an accounting and figuring out how much was in the estate, how much we paid out to the estate, from the estate, and then eventually figuring out who gets what when it comes to distribution. So if there's a will, we'll follow the will. If there's no will, we're going to follow the statutes of Illinois and figure out who's entitled to this money. Okay, so we'll also file a final report with the judge. We'll get some receipts from all the beneficiaries, make sure that they all agree on what they received and that they all agree on the executor fees and attorney fees. And last is I'll appear in court on your behalf to make sure we close the estate and discharge the person who's acting as administrator. So the liability will stop there and we'll be able to close the estate. So this entire process, minimum time is probably about 8 months. That's if everything goes well, best case scenario. But when people are fighting, when there's assets that are difficult to sell, there's just a myriad of reasons that can prolong an estate. So it can go as long as 2 years, 3 years. So I would say average time in our office is about 1.5 years to 2 years from start to finish. So hopefully you learned a little something. If you have any questions, you can give us a call. The information is below. And my name is Mara Tespot. Have a great day.